transcript as well. All right, so you should have that notification now. In terms of housekeeping, if you do have any questions, we've had a few questions that have been already asked upon the registration, so I'm going to go through those at the end. I think they probably be of interest, so I'm happy to share those with you. But if you do have any other questions as the session progresses, you can use the Q&A function. And again, I think it's either in the top toolbar, I mean, mine is there, or whether it's in the bottom of yours as an attendee, I'm not too sure, but you should have a Q&A function there. So any questions that you have, pop them into the Q&A function. I'm able to then keep a tab on them, and I'll come and review them at the end of each chapter, because I think that they will be relevant to the thing which we have talked about. So I'm going to split today's session into kind of three key areas, four including the summary and questions. Today's scheduled for probably around about 30 minutes or so, and allowing about 10 to 15 minutes for Q&A. I know if anybody joined the first session that we did slightly run over. I will promise not to do that today, because I appreciate that you've given up your precious time, and it's probably a lunch hour for you as well. So without further ado, again, for those who've just joined, thank you ever so much for attending the session. My name is Matt Owen-James. I'm a learning and development consultant. I work with Protect Commercial to provide various different types of education around insurance, helping people build their knowledge of commercial insurances, generally speaking, and also providing them with confidence to be able to talk about and to help diagnose what solutions need to be in place for clients as well. I'm not going to bore you with my credentials. You are able to read them. If you call them as credentials, I'll leave that for you to decide. Yeah, it's kind of boring, so I prefer not to do that. But I've been working with Protect Commercial now for the last, well, probably on and off for about 7 years or so, if not a bit longer. So yeah, so now we are really starting to think about how else can we provide support for our partners and for brokers. And one of them being the development of our Prono webinar series. So you probably had notification of those in one of the mailers that came out to you. And we're going to continue those throughout the year, because we really feel that it will be beneficial for you. And we really feel that that is, a really good opportunity, I guess. It's free learning, as it were. These things sometimes don't come cheap, do they? All right, so what is it that we are going to explore? Now, you've probably seen what those webinar objectives are. So there are three key things which I want us to be able to do. So the first thing I want us to walk away from the session is to understand the impact that the recent change of the Renters' Rights Act has had, and particularly around Section 21, okay? I'm really keen on exploring it from the the practical aspect of it, particularly when we think about what issues that may have on mortgage security. And then, of course, how can we then help recognize whether there is an insurance product in place, particularly for rent guarantee, on how that can really support, because there's only really one way now that a landlord is able to evict a tenant, which, because we're ultimately going, well, you can't do this anymore because Section 21 is now abolished, we now can only do that through court under Section 8 of the Housing Act of 1988. So the courts are going to be backed up. So I want us to get through and start to understand how things will be practically, how they'll sort of play out, really. And then finally, how to provide advice to clients should they be sort of facing and considering how we can manage the shift. I've read a report a couple of days ago. I can't remember where it was from, though, I must admit. But it was saying something like landlords are now considering the shift into HMOs and turning their houses into HMO opportunities to try and maximize the yield. But But then that in itself represents various different risks, doesn't it? So we'll have a little bit of an explore and go through those sessions today. We've also had a few questions come in as well around the CPD element of these webinars. Now, they're not CPD accredited per se. However, that said, what we mean by that is that they're not CPD accredited by the CPD standards, right? What you are able to do, however, is because these webinars are researched by a professional, they have learning objectives and learning outcomes for you to walk away with, so that you're able to take away a form of knowledge and apply it into your workplaces. You are able to manually record your CPD to satisfy your CPD requirements of the regulator. In the insurance aspect, they've now abolished it for insurance, but if you are CII, a member of the CII, for example, Chartered Institute of Insurers, you need a minimum of 35 hours structured CPD. You can include this as one of those, all right? So whilst it not be CPD accredited per se, because we'd have to go through all of that process, you are able to utilize the points. So 1 point for this session, despite it being just short, we're okay with it, to deliver that. All right, so please remember to go and record, and you'll have the recording for your evidence. We are also happy to distribute a certificate of attendance as well, so you can have that for your evidence. Okay, perfect. Good. So we're going to meet those objectives by 3 key chapters today. First one is just simply understanding what that legislative shift is all about. Okay, what has changed? What does it mean now for landlords? Then we'll have a look at what gaps that actually presents for them from a perspective of mortgage, well, from your perspective, I guess, and theirs of mortgage security, but also from an insurance perspective as well. What gaps does that allow? Well, what opportunities does that sort of present? So I want us to try and help identify, have you thought about this? And, really sort of raising that risk awareness, which will lead us very nicely into chapter or section 3, where we will explore how can we structure the conversations and how can we do that together, ultimately. So without further ado, let's dive into the legislative shift. Okay, so why is it happening now? So I want to begin with understanding, I mean, it's kind of been a bit of a contentious subject for quite a while. The bill was originally introduced under the Renters Reform Bill when the Conservatives were actually in power. So when Labour came into power, it changed from the Renters Reform Bill to the Renters Rights Bill. And of course, now that bill has been approved, it's received royal assent, which now means that, of course, it's an act, and it has been since the 1st of May. Now, this has been, it's been sort of publicised in the news, and I'm not sure where your understanding of it is on your own research, or maybe you've attended another webinar, maybe similar to this, maybe, I'm not sure. But it's ultimately, it rewrites the relationship that landlords and tenants have, because it hasn't been looked at since the Housing Act of 1988. And it's been a political talking point since before COVID, since probably about 2019. Conservatives put the white paper on, put the white paper through of a fairer private rented sector. They put that through, and of course the bill has now passed both houses, and as I said, it's now law. It's now an act. So the whole purpose of introducing the act was ultimately to look at the private rental sector in England, and we're concentrating on England particularly. The reason being is because in Scotland and Wales have similar laws to now what is in place in England. So I think that the reason being is to try and help bring everyone into alignment, I guess, but to also make sure that you have a fairer system. When we start to have a look at it, the main aim of it is to try and increase security, safety, and fairness, particularly for tenants. Now, Section 21 has been abolished under this, and Section 21 has always been a bit of a contentious subject under the Housing Act of 1988, because what it did was to allow landlords to serve their tenants notice of their intention to seek possession of their property. All they had to do was ultimately give a minimum of 2 months' notice. Landlords were not obliged to establish fault on the part of their tenants. Then, if the tenant didn't vacate the property within that time frame, then they'd have to go and seek a court order for possession. And then if the correct procedures were followed, then the court would grant the order. And the question which always presided was that fair? Was it always fair for was it fair for the landlord to go, right, I just want to simply take repossession of this property now. You've got two months to vacate. And now it's kind of up to you as the tenant. So it's always been a bit of a, as I said, a contentious subject. So what does this Renters' Rights Act do? So there are four main pillars of change. There are more. I'm going to run through other things as well, but these are the four kind of things which have been brought to attention in the news, and particularly which are going to affect landlords more than anything else, I think. Particularly around insurance aspects, and of course, particularly around mortgage security as well. So the first thing is the abolishment of Section 21, and effectively, it's being labelled through the media as no-fault evictions. Again, probably no surprise to anyone, because that is the thing which the mainstream media sort of concentrates on. And that means that now landlords can no longer evict tenants simply because their fixed term has ended or because they wish to take back the property without a specific reason. So yeah, it sounds, oh, well, yeah, okay, they should probably be doing that anyway. However, the repercussions of that, when we sort of add everything else in, can be more of a risk than landlords realise. So if we link that then with rolling periodic tenancies, so ASTs, so short hold tenancies, or short hold tenancies, with those fixed terms like 6 months or 12 months, they've now also been abolished too. So instead, all tenancies are now on a rolling periodic tenancy from day one, which means that the landlord is not able to gain repossession from the property after the fixed term is up, because there isn't a fixed term. There's no end ultimately to it. It's a rolling period. No longer will it be for 12 months and then, oh, let's renew it for another 12 months. And once from day one, it is sort of rolling ongoing. So now the tenancy can only be ended by either the tenant, who doesn't want to live there any longer, and they can do that by giving 2 months notice. But in order for the landlord to evict the tenant, the landlord needs to give a valid legal ground to evict the tenant. Which leads us very nicely onto the expansion of Section 8. So this was overhauled as part of the Housing Act of 1988, and the reason that it was overhauled is to sort of compensate for losing Section 21. All right. So Section 8 has been overhauled, and the focus on that Section 8 is to provide the grounds that the landlord has to evict. So Section 8 does ultimately, and we'll have a little bit of a look at what it means momentarily, but Section 8 is now the only legal route that the landlord has to evict tenants. Okay. So don't worry about what it is yet, because I'm going to come on to that in chapter 2 in the next one. Okay. So the only legal route that they have to do that now to evict tenants, including if they didn't pay rent. Well, one of those grounds is if they didn't keep up their rent payments. So, I think that's probably obvious. That's one thing that hasn't been abolished, I guess, which ultimately means that there are only certain things which they are now able to evict tenants. Okay, they can't just say, I want to live in this property premises now. It's too costly for me to do this, for argument's sake. Maybe the yield isn't as strong as it used to be. Maybe changes in regulations are changing smaller landlords to sell on to larger developers. I'm not sure. We'll kind of have to see what the trend occurs, I think. But nevertheless, there are only certain things which they are able to now do and to evict their tenants. Okay. And then finally, decent home standards, and that's bringing it to the private rental sector. So this has been something that has been ongoing for quite a while, actually. The government confirmed that in the new year, January, the decent home standard doesn't only just apply to social housing, but it's now brought under the Renters' Right Act and is extended to private rental sector too. It's not exclusively within the Renters' Rights Act, and it does therefore but it's linked, but it doesn't have to be done by the 1st of May neither. There is some time that the law allows this to happen because it realizes that it will need to build up cash and therefore it will need to take some time to do that. So full compliance for that is not until 2035, but there are certain timescales that needs to happen by, okay, in certain steps. So key things really: abolishment of Section 21. And therefore expansion of Section 8, I guess. So that is the only legal route now. And they can't end it at the end of that fixed term period because there is no fixed term period any longer. Okay. So quite a significant shift, actually. All right. Other things to, I guess, be aware of, because I think these things will affect insurance policies particularly. So first thing is to remove the blanket ban. So it's now illegal for landlords to impose those blanket bans when renting out properties, ultimately ending those things like no DSS or no children or things like that, right? Landlords cannot advertise or even implement policies that exclude entire groups. And that also includes those who are on benefits, right? So, the reason that I want to talk about this is because what a landlord now has to do is to assess the individual. Okay. They can't just say, we no longer, or we do not accept DSS. Now, the reason that people used to do that is because it was riskier, slightly riskier, in terms of damage, but also it was quite difficult or more costly to get insurance solutions. The reason being is because underwriters, their books, their loss ratios, were ultimately looking at, right, in this particular pool, with this particular type of tenant, we're paying out on more, or it's riskier because of, or the area that general property is generally in. So they were able to provide the data to ultimately back it up. So where landlords can no longer impose blanket bans on these kinds of things, they have to assess individuals. They cannot impose policies. The government said, I've yet to find any hard piece of evidence for this. I may have missed it. I'm not saying that this is entirely true, but my own research has yet to find hard evidence. When they were talking about the bill, well, when the bill was going through, particularly around blanket bans, is the government said that they were working with insurance companies to try and help get rid of the stigma that is attached with certain types of tenants. I'm yet to find any hard piece of evidence. The law is now in play. But what I will say is insurers are being a lot more flexible. We have started to see that in the market, where you used to previously have insurers that would just simply go DSS, no thank you, or whatever. I'm just using that as an example. What we're now seeing is insurers going, okay, and ultimately looking at it from the same way that the landlord now needs to look at it. So it must be checking upon things like affordability, references, credit checks. Not that the insurer will do that. The landlord needs to be doing those things because they need to, and they should be screening the tenants, but screening them against individually and against these particular things. Ultimately, not using any information or any personal or sensitive data that would discriminate them ultimately. So insurers are, and as I said, I don't know whether there has been talks in the background that isn't in public news or I may not be aware of. But yeah, what we are seeing is that insurers are being a lot more flexible around that to try and help and compensate. There are also terms and conditions that we're also seeing as a result of these changes now, such as credit checks, references. What is it that as the landlord, what are you doing to make sure that you are properly screening, to ensure that you know who is going in, so that we can try and help reduce that risk. Work with us. That's what the insurance company is saying, basically. Work with us. Okay. Second thing is the introduction of property ombudsman. Now, this is brand new. So there's currently a housing ombudsman service, but that service is to resolve any disputes between social housing and the tenants. Sorry, landlords and tenants in social housing is probably what I should say. But of course, like we've seen with the decent home standards, there will now be a private rental ombudsman to try and sort of bring social housing up with private as well. Okay. It's there to ultimately, well, it's expected to be introduced in 2028. At some point, late 2028 is what we are expecting. The primary purpose around it is to provide that free, impartial, binding dispute resolution service for private tenants for any complaints that they have against landlords. The whole purpose, again, is to try and avoid those costly court actions, making it fairer for the tenant. But also, it will help landlords. We believe that it will kind of force landlords rather than help. Force landlords and force accountability on the landlords, which again, tenants' rights, hence the reason for the bill. Keeping up on things like the standard of the home, of the property, keeping on top of repairs, any unfair treatment on how they were treated during the process. And ultimately, the ombudsman will then have powers to make the landlord pay up to £25,000 in any redress. Yes, registration is mandatory. Registration will be a legal requirement for private landlords. So it's another fee that they have to pay. And new registrations can be expected for, I think it was something like £28.32, which is a really random amount. Don't know why, but yeah, we can expect to see things under 30 quid per property that is put onto that database. It's not the landlord, it's per property. Okay. Although final figures and final processes are yet to be confirmed, but that's what reports show and demonstrate. Rent increases. Now, in tenancy, rent increases are limited to once a year under this Act, and landlords have to give 2 months formal notice for it. Okay, so again, the only legal way that they can increase that rent, it must be done through Section 13 of the Renters' Right Act. Now, what that means is that any rent increase must be brought in line with market value of the property's open market value. Landlords are also banned from encouraging bidding wars, and they're also banned from accepting bids higher than the advertised price. Tenants have the right to challenge any above market increases, and they can do that at a tribunal. But ultimately, yeah, it's trying to look at fair rents. So one question that we had come in is, well, was it a question? I think it was. We'll do that at the end. But I was listening to the radio, and there was something on there talking about this being introduced. one of the landlords said, who was a guest on the talk show, I think it was Radio 5 Live, I think, and basically saying, it's fine then, I'll just increase my rent to compensate for all of the changes and to try and build a cash buffer, because that's what I need to do ultimately. No, unfortunately not. You can't do it mid-year. And once that tenancy agreement has expired, that has to go into a rolling period anyway. So there and then is the only opportunity that you can increase it. As and when you do increase it, should you feel the need to, that has to be in line with the property's open market value. Yeah. And then finally, it sounds all doom and gloom, doesn't it, for the landlord? There are changes to it. Is it a fairer system? I would argue yes, particularly for the private rental market. Yeah, I'll leave you answer the rest. And then finally, we have the right to request pets. A simple one, but I want to talk about it from an insurance perspective. Again, in a similar way to no blanket bans, they have to be assessed on an individual basis. Requests have to be made in writing to the landlord by the tenant, and the landlord then has 28 days to respond. They are able to refuse the pet. That's not a problem. But again, it has to be legal or reasonable grounds that they have to refuse it on. So, for example, if the property is too small, or if other tenants in a block of flats have allergies, or if the pet is deemed to be a dangerous one, again, what is reasonable? Okay, so there's the shifts. So what gaps in cover does this actually present? So let's look, and this is where we'll really get into understanding what no Section 21 means and what Section 8 actually means. Okay, so let's just take it out of the legislative picture for a minute. And I just want to put it into a real world scenario, because let's face it, that is, for me anyway, at least when I see, paint a picture, it's where I really envisage it. Talking about laws and talking about legislation and talking about this and that, the other. For me, sometimes it's a bit like, okay, what does that mean in practice? And it's until we have it in practice that we will have a look. So I want you to meet David. David is a made-up person. The only reason that his name is David is because that's my middle name. So I just want you to imagine David, however that he looks like, right? But he's got a standard residential buy-to-let property, right? Rent, 1,500 quid a month, let's say, for argument's sake. His buy-to-let mortgage repayments are £1,000 a month. So running a little bit tight, but it's manageable, and he's got some margin in it. Okay. So new rules have kicked in, and tenant loses their job. They stop paying rent because they can't afford to do it. Okay. So let's map out what the timeline now looks like, and you can clearly visibly see it there. As a result of post-Section 21 abolishment, and only now able to go down Section 8. Okay. So months 1 to 2, the build-up, you have to give the tenant a reasonable amount of opportunity to pay. So they've missed June and July's payment, right? Tries to negotiate, the landlord tries to negotiate, but nothing really happens. Can't serve a no-fault notice anymore to just simply get them out. He's got to wait until the tenant crosses that legal threshold to serve a mandatory severe arrears notice, which can only happen from month 3, right? So we've got 3 months already without any rent coming in. There's enough arrears now for David to trigger that Section 8 mandatory ground eviction. So David then needs to gather all of the necessary evidence. But what's also required there is that David needs to serve a 4-week notice there as well in order to get into, to give the final opportunity for the tenant to do that. Otherwise, he will enforce this Section 8. Now, the tenant isn't panicking yet. The reason being is because David can no longer kick them out after that 4 weeks. that 4-week notice period now means that on month 4, that notice period is expired, tenant hasn't left. Under the old system, then yeah, section 21, fine. But now David must apply to the county court for possession. And the county court then has to hear, as a hearing, and it is based on fault. Okay, based on fault. Now, in this scenario, yes, of course, the tenant is at fault because they have not kept up with their mortgage repayments, of course. But this is where we really believe the system to kind of fall down a little bit, maybe, because it's going to create the bottleneck, because everyone now who wants to evict their tenants has to do that on a legal basis and has to go through the county court system. So there's going to be additional workload. And this is where the trap is, because every landlord in the country now has to go through this process for every eviction. Okay, so David's stuck in that holding pattern while he's waiting for that hearing date. The tenant is still in the property, legally not paying anything, and David's paying out on his mortgage £1,000 a month. And he's now doing that because he's only got a small margin and a small buffer. He's now doing that. He owns it in his own name. So it's his own savings which are being exploited, shall we say. Month 10, this is again, it's all sort of, it's a superficial thing, but it's not unrealistic of what we anticipate this to now look like. Month 10, David finally gets his day in court. Thankfully, he's kept really good records and his records are perfect and he can clearly show that, yes, repossession needs to be taken. So the judge grants possession, giving the tenant 14 days to vacate. 14 days pass, the tenant still refuses to leave. So guess what David now has to do? He has to now apply for the county court again for the bailiffs to physically execute that warrant. So what's that? Another 4 to 6 weeks. So yeah, are we looking at between a 10 and 12 month period where vacation? The landlord can take possession and to start renting it out again to continue and to get their money? Yes, is the answer. So if we just kind of have a look and paint a little bit of a picture around that and what it looks like for David, 12 months rent of £1,500. They haven't had that for 12 months, so that's 18,000. He's been paying 12 months at £1,000, so that's 12,000. He's got to pay for those legal fees. How much are they? 1,500, £2,000, maybe £2,500, maybe. That David's got to find, unless he has a form of legal protection or legal expenses on his property owner's policy. Maybe he doesn't. Not every policy does that. So yeah, that's a lot of money that David has to kind of fight. Now, how and what insurances are available to help plug the gap? So renters or BD Elite, which is sold here at Protect Commercial, and it's ultimately what's known as rent guarantee, because as we can see, the Renters' Rights Act has fundamentally increased the timeline and has it increased the complexity of evicting those non-paying tenants. Doesn't mean that you can't, it just means that it's longer. Okay, so this is what rent guarantee ultimately does. Okay, so it is something that effectively can provide, it provides the rent guarantee and legal expenses, and it aims to plug those exact gaps as we've seen in David. So the rent guarantee steps in to pay the undisputed unpaid rent until vacant possession is obtained through the courts. So it will really help. It's ultimately kind of a little bit like a loss of rent type cover, but you can't apply for the loss of rent cover on a traditional core property owners, because that will only kick in if there is damage sustained to the property and the landlord has had to evict the tenant and put them in temporary housing, or they can't pay there because it's uninhabitable, there's no insurable peril here for the loss of rent to kick in. So it's a similar kind of insurance policy. So it'll step in to pay, as I said, for those undisputed, unpaid rent until vacant possession is obtained through the courts. So it ensures that the landlord continues to have that cash flow to ensure that the mortgage repayments can be kept on top of. All right. And then, of course, with those legal expenses, they will provide up to £100,000 to cover the costs and expenses of pursuing those legal proceedings that they now have to go through in order to obtain those vacant, in order to obtain the vacant repossession of it. So it means that insurers then fund that legal professional advice to try and navigate these new, those sort of trickier, stricter court processes. How can we present this in the best light so the judge to go, yes, here's your order, to try and keep it as strict as possible. Sorry, as slick as possible, not strict. Because the courts are stricter. Okay. The pricing of the product is, I've put the little chart there for you. We can get this distributed out for you after the session today. It's not an issue. You can take pictures on screenshots if you wanted to. Again, that's absolutely fine. But the price of the product does differ, and it's based on per tenancy agreement and the amount of rent received under that particular tenancy agreement. Okay. There is a slight discount if you purchase it with the core product, with the property owners itself. Oops, sorry. With the property, too far. With the property owners itself, you can also buy it as a standalone product. That's not a problem, but it's slightly more expensive. Well, it's only an extra £10 per tenancy agreement per year. So it does kind of go hand in hand. As you would expect, there are conditions, and they're very much the conditions that we've talked about already. So I don't think there's any surprises here. So there does need to be a core identity and core credit checks, credit referencing, a clean financial history. They can also call upon previous landlords as well to get those referencing. That's absolutely fine. There is a requirement of income for the verification of it. Okay, so there has to be 6 months of references for if you are employed, and the landlord also, and if they're not employed, if they're self-employed, then the landlord has to have 2 years tax returns to screen and make sure, and ultimately sort of look and verify affordability, really. And then finally, when it comes to the affordability, gross annual income must be equal or higher to 30 times the monthly rent. That sounds like a lot, doesn't it? But if we just kind of do the maths on David, very quickly do my calculator, 1,500 quid a month times 30, then that's 45,000. And again, that's combined. So it doesn't necessarily have to be, it's the affordability on the tenancy agreement itself. Okay, or those within the tenancy agreement. Okay. So yeah, it may appear to be a lot, but when we put it into perspective, it isn't that. There is an alternative route, though. If there isn't that affordability check, then there has to be a guarantor with 50 times the monthly rent. Okay. Okay, so final thing which I want to conclude before we hand over to Q&A, just some conversation starters to think about with the landlords. And it's exactly what we're kind of going to be doing here at Protect as well. So don't just ask your client if they want insurance. Ask them questions that will thinking about what their risk is now when they're sitting down for those mortgage applications or remortgage review. Ask about cash flow. Explain the consequences of the Section 8 eviction process. How much liquid cash do they have for each property on their portfolio? And by asking those types of questions, then what we can really start to do is to understand what risk management process that they have in place for tenancy background checks to really help them understand if they're eligible for a payout so that we are able to then recommend that rent guarantee product. We're very conscious that we don't want to scare landlords, but what we do want to, and that's kind of our jobs, particularly here at Protect Commercial, is to, as professional risk insurance advisors, helping them realise what the risks are and how do they comply with new laws. Maybe we can now start to think about, are we buying insurance or are we buying mortgage protection? Particularly when we talk about the rent guarantee and the BD elite. Of course, that's what we're sort of, talking about here. Is rent guarantee confusing for landlords? I think it may be. Same as loss of rent. I think that can also be confusing for landlords too, because I think landlords would be, well, they haven't paid and I'm now trying to find a new tenant. Can I claim for my loss of rent? No, you can't, because there hasn't been a peril to trigger that that claim, for the claim trigger. That's what I wanted to say. There's no trigger for the claim. So kind of think about it. If are you buying that rent guarantee as a just in case? Yes, of course you are. But what if you didn't have it? What implications does that have? What does it mean for you now? Because you can't just evict tenants. You can't just say, oh, you're not renewing your tenancy agreement. They're rolling. Removal of Section 21. It's a much more long-winded process now. And costly, by the way. So we can, we know the product, we've got access to the market, we know who the underwriters, we know the knowledge of how this will work in practice. We've had training on understanding what this law is. I say we, I'm not employed by Protect Commercial, but the teams have had it. And the teams are aware of the changes and how they're going to affect clients and how they're going to affect mortgage deals as well, or how they could affect mortgage deals. So work with us, talk to your clients about it, help us understand what their risks are, so that we're able to then recognise, yes, that is something they can actually benefit from, and we can recommend that product. So summary and recap. So if you do have any questions, please pop them into the Q&A. We haven't had any yet, but we have had some. We have had 2 questions that have popped into upon registration. So I'm simply going to read them to you. We've had underwriting challenges in the past where our client has put benefit assisted tenants in one. I think we've talked about this already. Yeah, I did read this one. What are insurers doing as a result of that blanket ban? So yeah, very good question. You're right. Insurers did used to, and that tenant type particularly did affect underwriting decisions. But I think I've already answered that one. Insurers are now starting to change their appetites. They're starting to review individual risks to try and help with the landlord. I knew we'd had it already. So with the abolishment of Section 21, then surely a landlord can just increase the rent and to accommodate. So no, they can't. And again, the Act stops this, as we've seen. Okay, the rent has to be in market rate. The rent increases can only happen once every 12 months. The tenant can also challenge that. So yeah, and also there's no bidding wars neither. So can they just increase rent in order to build a bigger cash buffer? No, they can't. And they cannot, and then when they do so, they can only do so every 12 months as well. Okay. Okay, so I haven't had any other questions come in. If you do have any others, please pop them in and I'm more than happy to answer them. But to conclude the session, let's recap our learning objectives. So hopefully we should now understand the impact of abolishment of Section 21, understand what impact that has on landlord possession of their properties and impact on mortgage security, recognise whether rent guarantee policies, how they can help and how they can be compatible under Section 8 and the only route now, and to provide advice on areas that they should be considering to try and help think about how they can manage their risk. Because insurance isn't always there. Of course it isn't. And what I mean by that is there has to be an element of risk management themselves. Okay. And you can't buy an insurance policy particularly for that. Hence the reason for the rent guarantee as a standalone or ancillary product. Okay, it's not included automatically under the standard property owners policy. So from me, thank you ever so much. Thank you for attending. I hope that you have found the session enjoyable. I hope that it has given you some light and understanding of what this now actually means. By all means, speak to your broker support team, speak to the guys in the broking team around it as well when you're placing risks. They'd be more than happy to talk and to discuss it. But if you do have any further questions, by all means, just ask them, pop them in. You can email us as well. A copy of the recording will be distributed to you. And if, again, any questions or any support that we can provide, please just let us know. So I will leave you. Enjoy the rest of your day. Thank you ever so much. Take care. And I will speak to you soon on another Prono webinar. Thank you ever so much. Enjoy. Thank you.